is now in session.
Thank you. Please be seated. We're here for oral argument in the matter of Dana Nicole Prouty. Is that correct? Yeah, Prouty versus Bradley Hughes, respondent, and also the consolidated case of Ms. Prouty versus Adam Timothy Kafka. These are case numbers 1 CACV 160397 and CV 160402, consolidated for purposes of appeal. Counsel, I would remind you that we're recording this oral argument, so please identify yourselves and your client at the beginning of your comments. Each side will have 20 minutes to present your arguments. Counsel for appellant, please watch the clock and retain as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs. We have conferenced the case and discussed it this morning. With that, counsel for appellant, you may proceed.
Thank you, Jim. Good morning. Please the court. My name is Philip Nathanson. I represent Dana Prouty. I have to begin this morning in a way that I've never begun an appellate argument before, by re-urging a point that came up some time ago in the preliminary motion practice before this oral argument. While this appeal appears to be an appeal from what the trial judge, Judge Polk, called final orders, this appeal involves 2 out of 3 children of these parties. As it turns out, we're standing here on March 6th, I guess, and there is a trial scheduled for March 26th and 27th before Judge Polk for the 3rd child, Miles. And it gets worse. That trial is consolidated with a petition to modify custody as to Maxwell, who is...
Petition filed by whom? Petition filed by your client? Or
I believe so. Yes, I believe that's right, Judge. I'm not the trial counsel in the Superior Court. Mr. Garnice, Victor Garnice, a family law specialist, has advised me of these facts. I'm not involved in this trial, but I felt that under Rule 54B and Family Court Rule 78B, I guess, which is the same thing, Judge Polk's order as to 2 of the 3 children did not say there was no just reason to delay enforcement or appeal of what he called final orders as to those 2 children. And at that time that he entered those orders, proceedings as to Miles were still pending before him, and now they have ripened to the point where there's going to be a trial on 2 things: custody for Miles, the 3rd and youngest child, and modification of custody as to Maxwell. So I felt, given that it's incumbent to always inquire into jurisdiction, and given that I raised this some time ago.
When did you first raise it?
There was an eaten fruit procedure at the outset of this appeal. The appeal was filed. It was sent back for Judge Polk to look at something else regarding this registration issue. And at that time, I said, this is not really a final appealable order. It says final orders, but it isn't really, because there's no 54B or 78B. Honestly, I might have said 54B because I wasn't at the time plugged into the fact that the family court rules have a counterpart to 54B. But in any event, so I can't swear I said 78B, but I know I said 54B. In any event, I called the attention, and that was I don't know if it was explicitly overruled, but the court revested jurisdiction in this court after Judge Polk looked at what he was going to look at. So I just found out about this upcoming trial and that there are two issues, and I thought I should advise the court of, because I know the case is under 54B, I've litigated that before, say the court doesn't want to look at things twice, it doesn't want to deal with issues that are intertwined with other issues. And in rereading this record and these briefs for this oral argument, Judge Polk's, one of the reasons he gave for awarding custody of Madeline and Maxwell to their fathers was that Dana was caring for Miles, who was a developmentally disabled child. And I guess the custody is to Miles, and those circumstances are now going to be explored at this trial that's set for March 26th and 27th before Judge Polk. So,
Okay, well, you've alerted us to that. Unless the other judges have questions, I'd urge you to go ahead with your
thank you,
argument on
Judge.
the merits.
Appreciate it. Appreciate it. At the temporary order stage of this case, which became what I would argue sort of a self-fulfilling prophecy for the final custody determinations, Judge Polk decided to award custody to the two fathers of Madeline and Maxwell based on the avowals of counsel. And we submit to this court that a mother should not have her children taken away from her and awarded custody, awarded even on a temporary basis, based on the avowals of counsel. We cite the Volk case, V-O-L-K, in our brief, which dealt with this issue and ironically also dealt with the issue of limited time hearings in the family court. And I read the Volk case as condemning this sort of procedure, especially in view of what later happened at what purported to be a final trial, which basically reiterated what had occurred at the temporary orders stage of the case, where mother's time was severely limited as a pro per litigant, which, boy, there's pages and pages of the time constraints and the minutes in both sides' briefs.
Counsel?
Yes.
You're not appealing the temporary orders. That portion was heard, and then we moved on to a trial, and evidence was taken at trial, correct?
I can't agree with that, Your Honor, and let me tell you why.
Okay.
I'm sure we put the temporary orders in the notice of appeal, so technically they're before the court. But I don't want to hang my hat on that. I think we
I
are.
wouldn't, especially since there's a final order, and those get subsumed into the final order.
Well, here's what I'm saying. What happened at the temporary order stage, as far as we're concerned, as far as this mother's concerned, was basically rolled into the final order. Everything that occurred in the lead up to the temporary orders, which this court knows about the subject matter jurisdiction issue, the failure to register the Illinois order or judgment, everything that occurred at that ended up being subsumed within the final order.
After a trial where testimony was taken.
Such as it was. Our position in this court, as Your Honor knows, is that my client was given short shrift at this trial. That she
Didn't she take up to 2 hours the first day of trial, like dealing with administrative matters, dealing with handling of exhibits? I mean, isn't this another question, isn't this a highly, highly discretionary call for the judge to make? as opposed to the three of us?
Well, we raised due process arguments regarding the timing. As I understand the due process cases that we cite, when a party raises a due process argument and says that the time constraints were so inordinately short that they didn't have a chance to present their position, that this court reviews that de novo, not under an abuse of discretion standard. So,
what evidence specifically would Mother have presented that she was not allowed to do? Because anytime you throw out the word due process, we're looking at prejudice. How was she prejudiced?
well, she got 5 minutes apparently.
But what specifically, counsel? What did she want to?
She wanted to examine both of these fathers for more than 5 minutes. That's her, Your Honor, I wasn't there. She represented herself pro per as a layperson, which is what it is, I guess.
But she's bound to.
No, I understand the standard. I'm not arguing she should be relieved from some standard. But in view of the fact that this trial involved the admission of an expert report that is alleged expert report, because we attack the report and its admissibility in our brief. In view of the fact that Dr. Moran's so-called report was really the basis for what Judge Polk did and the basis for his findings, and that they didn't even call Dr. Moran as a witness, all those circumstances, his report was read into the record. He had never interviewed these children. I mean, this was, again, wasn't a vows of counsel, I guess, when you read an expert's report into the record without calling him. But Ms. Prouty didn't have a chance to develop.
Counsel, on the time of the allotment of time, and keeping in mind that there's discretion, a great deal of discretion in the Superior Court to manage the proceedings and to decide how much time each party should receive, couldn't the court, if we had about 2 hours of getting the procedure together and your client didn't turn in the exhibits when she should have, couldn't the court, I don't know, 15 minutes into it, when you can kind of see where this train is headed, that one party is taking up a great deal of time, couldn't the court have said, we're starting to count your time now? I mean, and
I don't think that's what he did. I suppose he could have, but I don't think that's what Judge Polk did.
So in other words, it's a way of characterizing how the time was spent. So to say that your client had only 5 minutes to cross-examine when really she did consume a great deal of the court's time set for trial.
Well, I didn't read the administrative wrangling at the start, which happens in a lot of trials, in my experience, as solely her issue. I mean, the parties were dealing with various preliminary issues before they got started. Her time was reduced by the judge by an hour, as the court knows. It's in the briefs, and all of those time things are argued. What concerns me is that you have a trial here where her time was not only limited, but the crucial evidence against her, this report, alleged report of Dr. Moran, who hadn't seen the kids, who based his diagnosed her with all these mental and psychological conditions based on some test. I mean, this should not have happened. And we attack the admissibility of that report. That is not controlled by Rule 2 of the Family Law Rules of Procedure. It doesn't cover the expert witness rules. It says unless you file a notice, all these rules are replaced, but it doesn't list Rules 701, 702, 703, and 704 as replaced. So should a court make a custody determination like this with two children based on reading someone's report into the record without foundation?
Was there a timely foundational objection made?
I don't know that she used the word foundation. She objected to the admissibility of the report. What was the colloquy is in the briefs, Your Honor.
What did she say?
I don't recall the use of the word foundation. She mentioned that he had not interviewed the children and had not seen the children interact with either parent. That, to me, as a lawyer, is a foundation objection. As a layperson, I don't believe in all candor that she used the word foundation, and I hope the court will let me reserve some time for rebuttal.
Yes.
Thank you.
Good morning, Your Honors. May it please the Court. Daniel Beeks on behalf of the Appellees, Bradley Hughes and Adam Kafka. It is kind of a strange way to start the appeal for the appellant to say we shouldn't be here on appeal because we didn't have jurisdiction. Appellant filed this appeal after before they sought a stay from you guys to send it back down to Judge Polk to reconsider for the umpteenth time the UCCJEA jurisdictional issue again. Once Judge Polk held an all-afternoon oral argument on it, issued about a 15-page ruling on it, reinstated the appeal, filed a docketing statement saying this was a final judgment and ready to come up on appeal, and then this morning says we shouldn't be here, and apparently now wants to stall the appeal some more. I think that is long since passed. They certified that this was a final and appealable judgment, and we ought to go forward. I guess if they want to stay it, things kind of are working in our ways. My clients have pretty much 100% custody of the kids right now, so I'm kind of surprised that they're not chomping to get this reversed and trying to stall it, but that's up to them. It seems to me that if there is an ongoing proceeding in the Superior Court and Mother thinks that because this is on appeal, they should be filing a stay in the trial court because jurisdiction is exclusively here until you guys stay the appeal. It isn't for you guys to stay yourself and send it back to the trial court. They need to seek relief in the trial court, not here if that's their issue. I guess, I don't know that it matters, but I'm not sure that this was a true eaten fruit issue. It was more they requested that you guys stay the appeal here so they could take up with Judge Polk the motion to vacate because they'd filed their motion to vacate in the trial court. Judge Polk said, whoa, this is on appeal. I've got no jurisdiction. So then they came up here, got a stay, and then went back to the trial court. It's not a true eaten fruit where we just didn't have a signed order, which is at least the only time I ever see eaten fruits coming out of this court. So putting aside all of those jurisdictional issues for today, it's kind of hard to beat Judge Polk's 150-page findings. He's laid it out in excruciating detail, and for the most part, we believe he got it right. Same thing for his ruling on the motion to vacate from May of 2017 on the UCCJEA registration subject matter jurisdiction argument. He got it right there as well. It's also interesting that we're back here today arguing about temporary orders again. I'm sure you guys remember, it's probably in the briefs, but we've already been here before on the temporary orders issues. After the temporary order issues came out and those rulings took place, Mother, through prior counsels, Stan Murray, a well-known, obviously, family law appellate attorney, filed a special action in this court trying to deal with the temporary orders. This court denied jurisdiction. Mother filed a petition for review with the Arizona Supreme Court, also denied review. So we've already kind of been through this temporary orders dance before, but at the end of the day, the judges, your comments in speaking with Mother's counsel are exactly right. Temporary orders are irrelevant at this point. We've had a final trial. We took final evidence. We had a 2.5-day trial, and under Rule 47M of the family law rules, after we do have a final ruling, any temporary orders are ineffective and unenforceable. So at this point, anything that happened way back when and would have affected the temporary orders is irrelevant. And we've got final orders, and that's what's governing us today. Moving forward to some of the other comments you had, yes, you're right. Mother did spend 2 hours. I mean, and Judge Polk actually commented on the record that it had been 2 hours, that they were monkeying around with all of the problems caused by Mother not filing her pretrial on time, not submitting her exhibits on time, asking all sorts of procedural questions because she was representing herself and she didn't really know what to do. Now, Mother has a constitutional right, as we all know, to represent herself. But as this court, and more importantly, the Supreme Court, have repeatedly said, if she's going to do that, she's held to the same standard as a lawyer. And that means the same understanding of procedural rules, the substantive law, and the same requirement to comply with deadlines imposed by Judge Polk for doing such things as submitting a pretrial statement, submitting your exhibits, responding to discovery requests, responding to motions for sanctions, knowing that you need to make an offer of proof if you're out of time and have not had an opportunity to do something you wanted to do in cross-examination. Mother was held to that same standard, and she failed miserably. She didn't submit her pretrial on time, didn't submit her exhibits on time. Most importantly, for at least some of these issues, didn't make an offer of proof to show what she would have elicited had she been allowed more time to cross-examine either of the fathers. I find it most interesting that we're here today and there's still no explanation for what Mother would have elicited in terms of testimony, even though we raised it in our response brief. Nothing even in the reply brief that she would have asked him these questions, and she was precluded from presenting this substantive evidence. So I think the court is correct. There is great discretion in the trial court as to how to manage its time and to impose reasonable time limits. This court said in Gamboa, and it's true, rigid time limits are not favored. You need to be flexible. Well, let's look at what happened in this court in Judge Polk's trial. Was he flexible or was he rigid? We got to setting trial. Judge says, I think it should only take a day and a half, but I'll give you 2 just to be safe. We get into this first day of trial. You can see it, the train wreck is happening because we've wasted 2 hours on administrative items. He tries to cut back the time proportionally for everybody. He gets into the second day and says, we're not going to make it. And he grants more time. So he was flexible. He wasn't rigid. He didn't strictly enforce these time limits. And quite frankly, this court has repeatedly said, although you need to be flexible and provide due process, the court is not required to indulge ineffective use of time by litigants. And in this case, that's exactly what happened. We cited to it in our brief, but there was a point in the trial court where Judge Polk finally had to stop Mother and say, you spent the last 10 minutes or so arguing about temporary orders, and he had basically the same response you guys have had today. That's water under the bridge. I'm not going to tell you you can't argue about it, but I don't think it's relevant for today. Mother had wasted her time doing that. Mother spent time calling other witnesses rather than cross-examining the doctors. That's her choice. She can use her time however she wants, but the judge is not required to indulge her inefficient use of the time. If that was the case, every time a pro se litigant ran out of time, there would be no time limits. And you're all aware, I mean, under the extreme time limits family law cases experience compared to other cases anyway. We get 3 hours, maybe 6 hours if we're lucky to try an entire complicated cases compared to, what you'll call, I think earlier, a red car, blue car case in the prior case. They get 3 days to have a jury trial on that stuff. So you have to have pretty great discretion in the trial courts to manage their calendar, manage their time, and respect due process. But in this case, Mother had all the due process she was entitled to. What does due process require? Due process requires the opportunity to cross-examine these witnesses. Mother had 4+ hours to put on her witnesses and to examine her witnesses. She had the opportunity, she just didn't use it because she used her time inefficiently. I'll skip quickly to...
Counsel, I was just asking, what was the nature, maybe this is where you're going, but the nature of Mother's objection to Dr. Moran's report?
That's a good point. I was going to go there next, but to answer your question, Mother actually did use the word foundation in making her objection. Her 2 bases of when she explained why there was no foundation was, number 1, and this is all covered in the brief, but Mother had not paid what she had agreed to pay for Dr. Moran to prepare this report. And so the trial court was left in an unenviable position of what do we do now, and basically had, over the series, a couple of hearings, said, well, do the best you can with the information you have, and tell us in your report what information might have been helpful that you didn't have. That was one of the objections Mother raised, was that wasn't in the report. And Mother's second objection on foundation was that Dr. Moran had not interviewed the children. Now let's talk about Mother's objection on not interviewing the children. That is perhaps the most ironic argument to this whole case. And it's outlined in our brief, but when Dr. Moran was appointed and there was discussion about Dr. Moran interviewing the children, Mother said, no, I don't want Dr. Moran to interview the children. I want the children interviewed by Conciliation Services so we can save some money. So to the extent that would be an error, it's an invited error. Mother wanted the children interviewed by Conciliation Services. The record is crystal clear that they were interviewed by Conciliation Services and that Dr. Moran reviewed those reports and reviewed those interviews. So there is no error in that regard. To the extent that Mother raises in her appellate brief all sorts of ethical and professional standards that Dr. Moran allegedly should have complied with in preparing his report, none of those were raised in the trial court. They were only raised for the first time in the opening brief. Obviously, I don't have to tell you that arguments raised for the first time on appeal are waived. So that also is, Mother didn't do her job. Let's talk about Dr. Moran's report in a little more detail, though, because when Judge Polk appointed Dr. Moran, and as you probably recall, this because of the way this case dragged on, Dr. Yee, who, if you've ever done much family law, he's a well-known name. He was originally appointed to do the comprehensive family evaluation, and he retired, and that's how we ended up getting Dr. Moran. But the order appointing Dr. Moran stated exactly in the order that Dr. Moran's report will be admissible in evidence at trial over any hearsay or foundational objections or any other objections. It said that in the order. When that order came out, Mom was represented in the trial court by Stan Murray, the attorney we talked about earlier. Neither Mr. Murray nor Mother at any later time objected to that order saying that Dr. Moran's report would be admissible in evidence without any foundation or other objections. With that, it's somewhat ironic that we're now hearing Mother's attorney saying we were somehow responsible to subpoena and call Dr. Moran as a witness so Mother would have the opportunity to cross-examine Dr. Moran. That's not the case. We had an order that said we didn't need to do that. More importantly, however...
What's the date of that order?
It's in our brief. Let me see if I can find it real quick.
Well, she was still represented, so.
Yeah, it's in Kafka's. I only have the record on appeal site of 158, and that's in Kafka's record on appeal. So
Okay.
I don't have the date right here, but
58?
158. So in this case, I think where I left off, Mother had listed Dr. Moran as a witness, stated in her pretrial statement she intended to cross-examine him. Nothing stopped her from doing that. Nothing stopped her from serving a subpoena on him, getting to come into court, and she could have cross-examined him. She had that opportunity. That opportunity is all that due process required. Unless there's, well, I always expected the reason we were here today is because you guys had questions about the UCCJEA jurisdictional issues, and I don't know that we really got there during Mother's attorney's argument, but in our view of the world, Judge Polk got it right. He cited to 3 cases from other jurisdictions that have held that registration is required for enforcement, but not for modification under the UCCJEA. The UCCJEA has different jurisdictional provisions than does the Uniform Interstate Family Support Act, UIFSA we call it, which was the basis of this court's decision in Glover that said at least when you're modifying child support, yes, it is a jurisdictional prerequisite, but the structure of the UCCJEA dealing with custody orders is different. The statutes are different. There are no provisions tying registration to jurisdiction under the UCCJEA. The UCCJEA provides for jurisdiction to modify in 25-1033, and that only requires that, number one, Arizona have power to issue an initial determination, which basically requires Arizona to be the home state, and that one of two things has happened. Either the original state, in this case Illinois, say it no longer has jurisdiction, or the Arizona court to determine that neither parent or the child continues to live in the original jurisdiction here, Illinois. In this case, you've got both of those options. The Illinois courts found 3 different times that jurisdiction was now in Arizona and they no longer had jurisdiction. And more importantly, Judge Polk found everybody had moved away from Illinois, so and that Arizona could make an initial determination under 25-1031. So the only cases Mother has cited are an old pre-2015 unpublished opinion from this court saying that jurisdiction under the UCCJEA required prior registration. We've cited in our supplemental authority, which I'm sure you've now seen, the Lewis C. versus DCS case from 2016, which is another unpublished case from this court, holding that no, registration is not required for modification jurisdiction. So to the extent that there was any Arizona authority that held otherwise, there's at least now a conflict, and the only one that's even slightly precedential is the 2016 one. And we've got the 3 cases from other jurisdictions, and this is, after all, a uniform act, holding that jurisdiction does not require prior registration. Yes, it does for enforcement, but not for modification. So unless anybody has any questions, I see my time's about up, and I'd probably beat this dead horse as long as you need me to beat it.
Questions? Thank you.
Thanks.
Counsel just told the court that Judge Polk was correct, that everyone had left Illinois. Dana Prouty lives in Illinois right now with Miles. She was in Illinois when Madeline was taken away from her in the Circuit Court of Lake County in Waukegan, Illinois. My associate was in the courtroom when the deputy sheriff literally took Madeline out of her arms in Illinois and shipped Madeline to Nebraska to be with Mr. Kafka. So the Illinois connection was alive then and is alive now. Now I want to speak to what Judge Cruz asked me, because this is on page 34 of counsel's brief. The quote from the record regarding her objection, I didn't remember the word foundation, but I'll take his word for it. Mrs. Prouty said, and this is at pages 203 and 204 of the trial transcript from January 13, 2016, Mrs. Prouty said, and I'm going to paraphrase a little bit, it was also known that Dr. Moran was, part of his report would be to meet with the children, including Father Hughes' son, Maxwell, and Madeline. That never happened. So I believe that report to be not of substance, because what this court ordered him to do is not included in the report. And how can recommendations be made by a provider when children were never even interviewed or even observed? And the court said to her, all right, Mrs. Prouty, again, that goes to the weight of the evidence, not to the admissibility. Now, counsel argued to this court just now that she was represented by counsel at the hearing appointing Dr. Moran, and that there was a provision put in the order at that hearing that no objections would be made to the report, and that her then counsel didn't object. Her position on the record in her objection was that Judge Polk in that order ordered Dr. Moran to interview and see the children and evaluate the children, which he failed to do, and that violated his own order. So whether counsel objected to the entry of that order or not, Mrs. Prouty's position in part was that the order was not complied with because Dr. Moran he was the evaluator of the children and custody of the children. He never saw the children. He never saw the children interact with the parents. So that is the position she has asked me to assert to this court. That they cite on page 30 of their brief this order that was entered, which is, I guess, KRO 158, which counsel just mentioned to the court. And they slightly disagree with what I just said, saying the order appointing Dr. Moran did not order him to interview either Madeline or Max. Well, the court can read the order and see whether Judge Polk, I read it that he was supposed to interview. If he didn't use the word order, he didn't use the word order. He was supposed to interview these kids and evaluate the kids, which her position was he never did.
I thought she objected to that. I thought she didn't want counsel. Is opposing counsel wrong on that? He said that she objected to that and wanted conciliation services to do that.
I don't want to Judge Brown, I don't want to criticize my client, but if Judge Polk ordered Dr. Moran to do certain things in an evaluation, I don't think it was up to Dana Prouty to decide to save money whether he should or shouldn't do them. And so her later objection at trial that he didn't do what he was ordered to do, I think is a proper objection. Whether she said as a pro per litigant that we should save money, if she said it, she said it. Now, I do want to, before I sit down, get into this issue of the registration of the Illinois order, which counsel referred to. On page 5 of the...
What's the difference between registering an order and domesticating an order?
I think domesticating is just filing it. You just file it in the court file. Registering it, there's a whole procedure for verified. You have to have an affidavit with it. You have to certify that it's never been modified, which it had been, as I understand the facts of this case. So there could not have been an affidavit so certifying under the statute 1055. I believe it's 25-1055. And there has to be service, formal service on Dana Prouty. And they concede on page 5 of their brief, the appellees, Kafka filed the Illinois orders in Arizona, filed them. Kafka acknowledges that he initially failed to register the Illinois orders in compliance with ARS 25-1055A. On the next page, on page 6 of their brief, they concede that even though they tried to fix that after the fact and have it retroactive, they concede that the clerk's office then mailed mother a notice of registration, but it unfortunately went to the wrong Arizona address rather than her protected Illinois address that was on file with the clerk. So she was not properly served. So there's a concession here that there's no registration. This squarely presents the issue to this court: does the Glover case require registration, which to be sure is a child support case? So does that child support case require registration in a child custody case, not a child support case? Why in the world you would require registration for child support payments but not modification of custody? No rationale for that dual interpretation of this statute has been offered. And we submit, and the arguments are copious in the briefs. I see my time's up, so I'm going to rely on the briefs for the rest of my argument and thank the court for the court's time.
Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. That we now stand adjourned.